So we are going to start with chapter 10. All right. Uh, so there is Article 32 of GDPR clearly mentions that you need to implement appropriate technical and organizational measures. So technical and organizational measures is not dictated by the law. In fact, no laws in the world dictate what technical controls you need to implement. So it always leaves the decision to be taken by the organization based on the threat landscape and based on their risk appetite. So you need to look at the sensitivity of your processing. You need to look at how automated you are. What is your business process? There's a lot of factors in helps you to select your appropriate technical and organizational measures. When it comes to technical measures, there are different options like you're gonna look into the technical controls like firewalls. You're gonna look into data encryption, consent tracking, and audit logs, and organizational measures including your policies, procedures, conducting DPIAs, and implementing different aspects of procedure and organization. These are some of the examples. So I'm going to touch one important topic part of this chapter, which is the data breach notification requirement. All right. So what constitutes a data breach is a very important topic, and there is a mandate in GDPR that you need to report any data breach within 72 hours after you are aware of the breach. All right. So which means the clock starts ticking the moment you are aware of the breach. What does it mean? There could be a 0-day attack. A 0-day attack means there is no known signature of that particular virus available with any of the antiviruses or available with any of the researchers. So these 0-day attacks are highly difficult for you to even know that there is an attack in your organization, right? So that is a differentiator, that the clock starts ticking only from the moment you are aware of the breach. And the moment you're aware of the breach, you have 72 hours. The 72 hours is not a delayed time, but it is the time for you to do a lot of assessment in terms of understanding the breach, understanding the impact of the breach, and you need to come up with the mitigation steps. So the moment you inform the supervisory authority before 72 hours, you need to give all this information in terms what is the cause of the breach, what is the impact of the breach, and how many data subjects are impacted, what is the volume of data which has been breached, and what are the categories of data which has been breached, and also you need to inform the mitigation steps which you have included, right? So this is a very important activity which you need to do within the 72 hours. All right. So one important exam question that is always tested is, as a processor, you when there is a breach happening in the processor environment, right? Is it an obligation for the processor to inform the supervisory authority or the data subject, or he should inform the data controller? What you would choose in this case? Participants can maybe type in. So I'll repeat it again. There is a data processor whom you have hired for for the data processing activity, and there is a breach at the data processor environment, right? So in this case, what should generally be done? They are bounded by the contractual obligation that they need to always inform the data controller. The reason is the data controller is the one who has to take the decision in terms of whether it has actually a breach that will require a notification or not. I believe I've kept some scenario questions for this. Yes, so we will discuss them during the scenario questions. Now, once you have informed your once you are done notification to the supervisory authority, as I said, you have different components which you need to mention to document part of your notification, and there are specific triggers in terms of when you will notify a supervisory authority and when you will notify a data subject. So as per GDPR, whenever there is a risk to the rights and freedom of data subject, then you need to notify the supervisory authority. And whenever a breach causes high risk to the rights and freedom of data subject, then you need to notify the data subject. So very simple. Okay. Whenever there is a risk, you need to notify data protection authority. Whenever there is a significant high risk to the rights and freedom of data subject, then they are to directly notify to the data subject. So what constitutes risk and what constitutes high risk? It's a purely subjective call, and a decision whatever you take, it needs to be adequately documented. You need to defend it as well. If you decide that it is not a significant breach, then the supervisory authority will definitely question it, and you need to defend it as well. How do we defend it? Depends on what sort of controls you have in place, what sort of mitigation controls you have in place, and you can prove that the risk will definitely not cascade into a significant risk, right? So this is the way generally it works in practice. And it again, even you may take a decision not to inform a supervisory authority, considering that particular breach scenario will not cascade into a risk to a data subject, right? So this is a very important exam topic which is often tested with multiple case scenarios. I'll be sharing some of the case scenarios. You can answer them. An employee was traveling with his laptop in metro. He was advising a hospital client, and laptop contained lot of sensitive personal information of the hospital. The laptop was stolen during transit, and the laptop has enterprise controls, including encryption and remote wiping option. All right. So, what do you think in this particular scenario? Does the organization, consulting organization, do they need to inform the hospital? Also, do they need to inform the supervisory authority? So, the answer to this case is that you will not be informing to any of the people like supervisory authority or the data subject. The reason is the information which was there in the laptop is completely encrypted. It is having an end-to-end encryption in most of the MNCs, right? And there are corporate data protection controls which includes your remote data wiping options as well. So in this case, the moment you are aware of the breach, even if there is a small gap in between, if someone is trying to heckle your laptop, it's impossible for you to get any meaningful information out of that laptop, correct? So in this case, it is definitely doesn't have any impact on the data subject, correct? So that is the reason you should be choosing the option here, that it doesn't require a notification to both supervisory authority as well as to the hospital, right? Could be little surprising to you, but you need to look at impact assessment. In this particular case, if you do an impact assessment, clearly there is no impact or risk to the data subject, and that is the reason we are going to choose that. So when we choose that not to report to the data subject as well as to the supervisory authority, it doesn't mean we are not recording this breach. We definitely need to make a documentation of the breach. We need to mention that this is a decision taken and this is because of the impact assessment which you have done. All right. Maybe little difficult for some people to digest, but that is the actual answer to this. So don't worry, I have a lot of experience in this, and this is the answer which supervisory authority do not agree with this. So you will not even go to the supervisory authority. That is my point. It is not about even see the first level is going to the supervisory authority when there is a risk. When there is high risk only, you will go to the data subject. If you're not even going to the supervisory authority, how does supervisory authority will know? Correct. Jarek? Jarek, actually, it depends on the scenario. In this scenario, there is no even a requirement to even report to the data supervisory authority. It is a breach, but just that it doesn't have the impact to have a risk on the data subject. Okay. Sorry. For the second question, what is your thoughts? Question two: a bank employee sends a customer file to the finance member, and it was supposed to be sent to the sales team. So the finance team member opens the document and deletes after identifying that it was wrongly sent. Okay. So the breach is internal only, as someone Kasia said it. That is right. It is definitely an internal breach. But do you think in this case, do you need to inform the supervisory authority or the data subject, even though it is internal? It is a sort of a breach, I believe, because the wrong people have opened the document, and it is actually a breach of role-based access control as well as least privileges, all these things. There are doctrine of accessing deploying access control, right? In this case, if you see, the person was supposed to not to know the document. So it is a breach, and you don't need to inform both the supervisory authority as well as the data subject. And the only reason is if it's an internal breach, because all the employees are bounded by NDA, non-disclosure agreement, right? So in this case, you will definitely not require to notify either supervisory authority as well as the data subject. Okay, let's go to the third one. Cloud service provider had a technical glitch and its servers were not available to its customer for 2 hours. Is it a data breach? Later, it was identified as a ransomware attack. It's actually a data breach because availability is getting affected, right? So does it require a notification? Answer is no, because it doesn't have an impact on the data subject. See, the moment it becomes a ransomware, again, you need to do an assessment in terms of whether the data subject is going to be impacted or not. Certain ransomware attack are done just by pure encryption, and the hacker doesn't have an access to to decrypt the file and have a view at it. If it's only a plain encryption ransomware attack, then there is definitely no need to inform the data subject in this case. But with the moment it becomes a ransomware attack, right, I think it is safe to inform the supervisory authority, because it is definitely having a potential risk, because we don't know the other end of the hacker, what sort of algorithm is using. Can he has the ability to actually uh, read or have the access to the data? What extent of hack is this? So when it comes to ransomware attack, the clear assessment will actually reveal whether you need to go and inform the supervisory authority or not. In many of the cases, it is better to go and inform the supervisory authority when it is a ransomware attack and you are not clearly aware of the impact of the ransomware attack, right? Who takes the decision when to inform or not to inform? The data protection authority or the data privacy manager, in consensus with the top management. So on question number 4, the list of participants, like we are all participants of this webinar. There is a training program, and list of participants on the training course is sent to 15 former participants by mistake. 2 participants had filled their food preferences, stating that they are lactose intolerant. Right, the controller discovers the mistake and immediately and asks the recipients to delete the list. Okay, so if you see this particular case, there is a training program which is conducted on a hotel, and people are asked to fill their meal preferences, and so people have mentioned, and some people have mentioned that they are lactose intolerant, right? But this list has to be sent to a wrong list of uh, your past participants, right? Which means it's clearly confidentiality failure, right? So it's definitely a data breach. In this case, do we need to inform the data subjects and supervisory authority? It's a subjective call. Many people will think like, what is the problem with that? But lactose intolerance is falling under the scope of health data, right? So I would say it's a 50-50 call, but it's a safer side to inform the data subject. And being lactose intolerant coming under a sensitive personal data category, I would generally take a chance of informing the supervisory authority as well as data subject to ensure you provide the sufficient information to the data subject that yes, we have asked the recipients whoever received by this mistake to delete it, and we have ensured that they are deleting it. But at the same time, you should be aware that this message got leaked. All right. So that is option 4. Question 5. During a period of notice, the legal intern copies customer contact list from the database. Months later, after quitting the job, he uses the same data, thus gained, to feed a new data processing, which is to directly reach out to those customers, and so to entice them with to his new business. So it is definitely a data breach, but do we need to inform the supervisory authority as well as the data subject here? So there is a case called disgruntled employees. So disgruntled employees are a very, very difficult factor and difficult risk to control with for any organization, right? So disgruntled employees means the employee who is not happy with the organization, he leaves, or within the tenure he tries to damage the organization, right? So one such employee is this employee who actually copied some information when he was actually working, isn't it? So uh, this is a internal human error, I would say, to start with. And then that human error, it's not a human error, it's a fraudulent activity. Better word is that. And so after he copied the data, he's actually reaching out to the customers of the actual company, isn't it? So the moment he reaches out to the any customer, they will obviously reply that message back to the actual mother organization, isn't it? So in this case, it's definitely a data breach. And does it affect the clients? It depends. In most of the cases, it doesn't affect because they are not going to be convinced with this person, and they will obviously going to report this to the supervisory authority that an employee has done a fraudulent activity. And any employee who leaves the organization also, there are terms and condition even after you leave the company. So there is definitely going to be a lawsuit which will be filed against that particular employee, and the situation will be definitely contained. So in this case, I would recommend that you need to reach out to the supervisory authority and inform about this particular case, but it doesn't have a significant risk in this case. A malicious code made from personal information submitted through online job application form and stored on the web server accessible to unauthorized persons. The hacker installed a toolkit which allowed to remove any history of exfiltration, monitor the processing on the server, and capture personal data. It was discovered only after a month after its installation. This- So yes, most of you got it right. It's definitely a data breach, and in this case, there is some malicious code inserted, and there is an exfiltration which is happening, right? So in this case, it has to be informed to both the affected data subjects as well as the supervisory authority, right? So in this case, there is definite notification which is required on both accounts, right? So I hope those case studies were interesting to you, and there are a lot of information case studies which uh, why data subject. See, it's a online job application forms, right? There is a lot of sensitive information about you would have been saved in that company. Am I right? And that's the reason you have to inform the data subject as well. Part of your online job, there is a lot of personal information is going to be stored. Am I right? Yeah. So that winds up your data breach notification section, and the chapter on security of personal data processing. Now we are going to look into a very important topic, which is accountability requirements. So this chapter has 4 minimum questions and maximum 7 questions. So in this chapter only, we are going to discuss in terms of what are the accountability of a controller and processor as per GDPR. Very, very important topic, not only from the exam perspective, but also for your day-to-day working as well. Let's get started. So if you look at the important obligations, it starts with maintaining internal records. When we say internal record, you need to have a documented records of processing activity. So records of processing activity are, along with the data flow mapping, is a very, very important activity for you to have a clear picture of what data is getting collected, how the data is getting processed, how the data is getting stored by different application and process. So that's a very important requirement. Any data protection authority is making an inquiry to an organization, the first thing they are going to ask is, where is your policies procedures? Show me your records of processing activity. So these two steps, these two questions will actually show what level of maturity is the organization in, right? If you have done these two, then obviously you are definitely in a better position to answer the subsequent questions, right? So the next important point is conducting data protection impact assessments. Before I jump in terms of DPIA, I need to explain to you what is the difference between PIA and DPIA. Okay, so it's a very, very important exam question as well as a common question which is asked in almost every interview you will attend. What is PIA? PIA is Privacy Impact Assessment and has been existing term for more than 20 years. And it's been used at a different level. It can be used at an entity level. For example, an entity is subjected to a data privacy law, right? If you want to do a gap assessment, you can do a PIA, right? And if there is a merger and acquisition, if two companies are merging, you can do a PIA. If there is a new process, new product launch, you can do a PIA, right? So PIA can be done at different scale, different triggers. Now, when I come to the term of DPIA, the term DPIA was coined in the GDPR. It's called Data Protection Impact Assessment. And it's a very GDPR specific terminology. Why I say this? For DPIA, it's been clearly drafted in GDPR. What is the trigger for a DPIA? So there are three important triggers whenever you are processing personal data in large volumes or if you're processing sensitive personal data. And third, if you are handling monitoring of publicly accessible places, then based on three of these important triggers, you need to conduct a DPIA, right? And part of the DPIA, it is also clearly drafted what are the important information you need to capture, what is the process flow. For example, in DPIA, you need to capture four important information. The first information is that what is the description of the processing. Second is necessity, adequacy and relevancy of the processing activity, and do you have a lawful basis to do that. The third is what are the potential risk for this processing activity, and fourth is what is the mitigation step to overcome those risks. So if you capture these four important elements, then you need to do the next important step is after mitigating the controls, if you still have residual risk, then you need to reach out to the supervisory authority. The reason is these DPIAs are conducted before the processing activity commences, right? For example, you're going to launch a new marketing campaign. If you're going to launch, you're going to bring in a new product, your new technology solution like ERP, right? So in all, you're going to do new analytical processing. So all these cases, you need to do this DPIA before the actual activity commences. And why do you need to do the supervisory consulting is that you need to check with the supervisory authority that I have implemented sufficient controls, but still feel that there is a residual risk and it can have an impact on the data subject. So the supervisory authority on its consultation role, they can definitely provide two options. One can suggest more controls to bring down the risk, or they can ask you to stop the activity until the residual risk is removed, right? So this is the process for DPIA. Why I'm explaining this? In GDPR, it's a legal mandate for you to do DPIA. Second, the triggers are clearly mentioned and the process is clearly mentioned. The documentation part is clearly mentioned, right? So the question that comes to your mind is, can I do a DPIA in non-GDPR jurisdiction? Answer is yes. You can do it for any jurisdiction. There is no problem with that. But if you are operating within GDPR, the mandate is non-negotiable. You need to do DPIA, right? And when it comes to PIA, can I do PIA in GDPR regime? Yes, of course, you can do it, but you cannot use PIA in circumstances where DPIA is mandated by the law. All right. So this is the clear differentiator between PIA and DPIA. For PIA, there is no fixed thumb rule in terms of what are the triggers and what are the documentation required. It is basically derived from the particular legislation you are working with. In the world right now, there are more than 190 data privacy laws, right? So each of the law come up with their unique terminology, and you need to look at, for example, if you go to Australian Privacy Act, you go to Singapore's PDPL, there are many laws around the world. Each law will mandate some or the other risk assessment, right? And one very common element between both these assessment is they are trying to assess the risk and trying to mitigate the risk to a data subject rights and freedom, correct? So in this case, the objective of both these assessments are one and the same. what we need to be mindful is when you will use this particular assessment based on the laws jurisdiction which you are working with, correct? So this is the difference between PIA and DPIA. If you are working in GDPR regime, so data protection officer is not a mandate. It is one of the, it is not a mandate for every organization. Okay. So it is a myth that everyone thinks if you are operating in GDPR, you need to appoint a DPO for each and every organization. Okay. So GDPR clearly mentioned the triggers where you need to have where you need to appoint a DPO following, for example, if your core activity is large scale processing of personal data or sensitive personal data. And only in those cases, you need to appoint a DPO, right? Again, DPO is a legally mandated position. Qualification, the requirements of discharging the roles and responsibility is being clearly captured in GDPR. For example, how important is this role is that if the person, he or she is discharging the duty but it's not helping the organization, so they think DPO is not trying to help the organization to cover up the mistakes, and he is getting fired. The 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 organization will be slapped with the penalty and the person will be reinstated in the job. So that's the reason it's a very, very significant role. If you use this terminology within the GDPR jurisdiction, it has a lot of weightage, right? So you can use this terminology anywhere in this world. There is no problem with it. But the moment you use this terminology in the GDPR regime, you need to be extremely careful because it's a legally mandated rule, right? And coming to data protection by design and default, again, so the I think Article 35 demands you to embed data protection by design and default. So there is a doctrine which was created in 1992, which is the data privacy by design and default principle. There are 7 principles which were developed, and these principles were officially adopted in GDPR for part of Article 35 requirement. So the 7 principles will be explained during my session. I will be giving a lot of example to make you understand that. The next one is codes of conduct and certification. So if you want to certify yourself, there is an option within GDPR which has been officially given to the organization. It was very dormant till last year. This year, I think it has started to get official certification, and that's one of the way to showcase that you are adopted the requirements of GDPR, right? So these are some of the other requirements in terms of whenever you do ROPA, can you give three examples for data protection by design and default? See, data protection by design and default is there in many categories. As I said, there are 7 principles. I will give an example for out of all the 7 principles in my session. But right now, since you asked, whenever you're designing a website, right? So you would be developing a website cookie banner, right? So the cookie banner generally states that what sort of cookies are going to be dropped on your browser, correct? So in this case, if you clearly mention the different categories of cookies, it could be functional cookies, it could be essential cookies, it could be your advertisement cookies, marketing cookies, or analytical cookies. So you need to clearly mention that what are the different cookies that are going to be dropped by the website on your web browser, and and you need to have a granular option of selecting each of them separately, right? Generally what companies make mistake is accept all and not giving option granular option to select them, right? So this is one example of data privacy by design, right? And I can give a lot of example for data privacy by design, which means whenever you are developing any product or solution, you need to embed data privacy requirement from the very beginning in the very initial stages, right? So do not retrofit privacy controls at the later aspects. Very simple aspect. I will give you a practical experience, which example which I recently encountered. So data subject rights is one of the important procedures which you need to implement. The process has to be implemented, right? So whenever you are validating a data subject to fulfill a data subject right, you shouldn't be collecting excess information. And for example, there is one company which collected excess information in the name of customer authentication, and they wanted to actually collect some more information like your Aadhaar card, PAN card, and like I'm giving an example, right? So the company intention was to actually get more authentication information about a user, and they want to use it for some other direct marketing activities, right? So in this case, it's a clear violation of your data privacy by design. The reason is it violates a principle called data minimization. So data minimization is one of the concept again within the data privacy by design and default, where you need to ensure data minimization in all the process. Collect minimum data, collect relevant data, collect adequate data, and collect the data which is as per the lawful basis, right? So these are some of the ways. In fact, you can create a big checklist of data privacy by design for most of the process. It's just if you have a good understanding of what it is, then it's only a matter of interpretation. You can develop many examples around it. All right. Data retention is another important element around your accountability as well as data privacy by design. So ensure you store information only till the period it is required. Never have excess information. And also in part of your international data transfer also, you can embed these requirements. So, if you see these aspects, these are nothing but your ROPA. Actually, I didn't give you that big picture. So the four important cells are nothing but how do you build your data inventory. When you build your data inventory, you need to ensure what sort of personal data you're collecting, what is the legal basis for doing it, what are the security measures, including a retention, and you need to also ensure you capture if the data is bound to any international data transfer, to whom it is getting transferred, and what is the lawful basis to do that. So the records of processing activity need to capture all these important aspects, and that is your record, internal record accountability requirement. All right. So this is DPIA. I think I already clearly explained to you. You can just have a quick look at it. So if you're going to do a DPIA under GDPR, you need to capture all these important information. It starts with systematic description of the purpose of processing and systematic description of envisaged processing activity and legitimate interest pursued. If there is a legitimate interest, you need to capture that. Assessment of necessity related to the process, assessment of proportionality related to the process, assessment of risk to the data subject, and also look at the measures envisaged to address the risk, right? So these are the different elements when it comes to your DPIA documentation purposes. So data protection officer, I explained to you in terms of what there are three important mandatory requirements of a DPO. So the DPO has to be appointed whenever you are a public authority and whenever you are doing large scale regular monitoring of personal data. And third, large scale special category data processing. In these three triggers, you need to appoint a DPO for your organization, right? Who's a DPO, what he does? So he's a GDPR privacy expert. These are the qualification requirement, and he can be either an employee or an external member, and he does periodically monitor the compliance, assist with GDPR independent authorities who are basically the data protection authority, report to the management in terms of a breach, in terms of an issue, and he is a single point of contact to the authorities, and he has to ensure secrecy and confidentiality. So another important point which I wanted to insist is that the DPO is not what you think, like a single man army who will do everything. So I'm keeping it very clear. Don't compare to the situation what could be in India or any other country. I'm always speaking from the European Union perspective. In European Union, DPO is a C-suite officer. So he is directly reporting to the top management. Don't expect him to be handling a data subject request query. Yes, he will be handling escalations on data subject raised, especially if it's breaching the required deadline, but he will not be doing the routine activities. He will not be conducting DPIA. But whereas if there is a decision to be taken based on the outcome of DPIA, yes, he will be there to take that decision. Monitoring the compliance is a responsibility, but he will not be doing all those operational routine activities, right? So you should be absolutely clear about that. So the last chapter which we are going to discuss is international data transfer. I hope everyone was able to get the different accountability requirement and felt I hope everyone enjoyed those requirements. What you need to facilitate if you are going to show accountability to GDPR. So let me get started with international data transfer. So when it comes to international data transfer, it's very simple. Whenever the data is going out of the European Union, then international data transfer gets triggered. So uh, for ease of understanding, I said European Union. If you look at the Venn diagram which is mentioned here, it's a very, very important piece of puzzle you should be aware of. So European Union has 27 member states currently. There are 27 countries within the European Union. And outside the European Union, there is something called EEA, European Economic Area. And within that, we have three countries, which is Iceland, Liechtenstein, and Norway. So the GDPR scope is at EEA, not at EU, at EEA. So what is the meaning of that? There are three countries which are not part of the European Union, but they have actually ratified GDPR in their economy, in their legislation, right? So these three countries are considered to be the boundary of GDPR. All right. There is one more country which is part of EFTA, which is European Free Trade Organization. So Switzerland is neither part of EEA or EU. So it is part of a special agreement under EFTA. So this GDPR is not directly applicable to Switzerland, but they fall under a special privilege called adequacy decision. All right. So I will be showing, so someone asked about UK. So UK is out of all the three Venn diagrams. Currently, they also enjoy the adequacy, but they come out of EU. So I think they might be part of EFTA now, and I'm not sure about it, but they fall into the category of adequacy decision. I'll be covering them in the subsequent slide. Okay. So to do international data transfer, you have basically three important instruments. Okay, so it's in the slide, it is showing four, but please correct your understanding. Actually it's a mistake in the diagram only. BCR should be part of the appropriate safeguard itself. So there are only three important instruments. BCR is sometimes considered standalone, but it falls under the appropriate safeguard. So there are three important instruments. The first is called adequacy decision. So what do we mean by adequacy decision? So there are countries which have been considered adequate by the European Union, especially the organization behind is called European Union Commission. So the Commission routinely identifies countries which actually provides the same level of protection to the personal data that European Union does. How do they evaluate this? So for example, a country that has a similar stringent law, or they have a data protection law enacted, they have data subject rights being addressed, and there are some 4 to 5 different criterias which makes the country eligible to become a adequacy decision country, right? Currently there are 18 countries. It's not only countries, certain sectors within a country can also be selected. For example, in Canada we have PIPDA, and UK also there are certain sectors which falls under adequacy decision, right? So adequacy decision is considered as a very essential way to do international data transfer. The reason is, the moment you come under adequacy decision, you don't need to consider any other instrument for transferring data outside the European Union, right? It's one of the most easiest way. Now let me go to the remaining instruments. These are the ones which are most important. To start with, appropriate safeguard, the first one is called standard contractual clauses, or ACC. So ACC has been long existing for more than 10-15 years, but it has taken a very important leap after 2020 judgment. So after 2020, there was an so I'll come to this European Union and US scenario where a couple of important framework were invalidated, and that is the reason the latest judgment came in 2020. You would have heard this particular case, which is called Max Krems. He's from NOIB. And let me not jump the gun. I'll start with ACC again. So ACC is standard contractual clauses. So standard contractual clauses have been now officially the templates for what constitutes a standard contractual clauses. The requirement has been released by the EDPP itself, which means you don't need to draft your own contract. The requirements, what needs to be adopted part of the contract is already released by the EDPP. So if you want to transfer the data outside the European Union, you need to enter into this contract with the data processor or any third party. All right. So the first is standard contractual clauses. The second is approved code of conduct. So approved code of conduct is done by industry bodies. For example, if you know the history of payment card industry, it's actually industry body like Visa and Mastercard. They came together and created a industry-wide code of conduct. Right. So approved code of conduct is very similarly within European Union. Certain industries can create a code of conduct, and once the code of conduct is approved by the supervisory authority, and then if it is if it is affecting multiple member states, then even the commission as well as the ADPP will come into picture. In that case, the code of conduct will be another instrument to do international data transfer. All right. And the third is privacy shield, which is actually wrong. Currently privacy shield is invalidated, and we have something called Transatlantic data framework between European Union and the US. Okay. And the third actually is your binding corporate rules. The binding corporate rules is for intra-group transfer. So I actually use this image from internet. Actually, this has some accuracy issues. So binding corporate rules is one of the appropriate safeguard itself, right? And so in this, the very important exam question we will be asked is that BCR, binding corporate rules, is used for intra-group transfer. What do you mean by intra-group transfer? If the data is getting transferred within the same umbrella of a chain of companies. For example, there is a parent company and there is multiple daughter or children company, right? So the parent company has a global presence and it has multiple units and subsidiaries spread across the world, right? So in this case, what you can do is create a binding corporate rules, and so every leg that comes into the binding corporate rule umbrella, they have to adopt and implement the requirements of binding corporate rules. So once it has been approved by the authorities and by the EDPB, then you can have this as a valid means of doing an international data transfer, right? There is something called ad hoc contracts. That is also a valid appropriate safeguard. Ad hoc contracts means, for example, SEC is non-negotiable. The requirements of SEC, which is released by the EDPB, is absolutely non-negotiable, and you cannot tamper any of the requirements which is mentioned there. But in case if you need to come up with a customized contract, right, and you have a multiple presence in multiple member states, so in that case you can go for something called ad hoc contracts. Again, this has to be approved by the supervisory authority, right? There is one more mechanism which is not mentioned here, which is called certification mechanism, right? Certification mechanism is again another important, which goes hand in hand in terms of what we discussed earlier. So certification mechanism is created in GDPR. So once you fulfill the requirements for certification, that also ensures that you have a stable protection requirement to facilitate international data transfer. So all these information, whichever I told you right now, comes under appropriate safeguards. That is the second bucket. The third bucket is called exemptions, generally called as uh, who certifies. So the GDPR has created a mechanism. So there will be a body which will be accreditation bodies will be created. Accreditation bodies will be vested with power to give certification. Recently, the first accreditation body has started issuing certificates. I think it's a 3-year cycle, and once you fulfill the requirements, you can get an official GDPR seal. Okay, that's again a very interesting development that is happening. Finally, we have exemptions or derogations. So exemptions is is it should be always narrowly interpreted. For example, you can do an international data transfer based on consent of an individual. So if a consent gives an explicit consent, if a data subject gives an explicit consent, you can do an international data transfer. Or if it is contractually obligated, for example, you have ordered something abroad. If a European Union data subject has ordered something abroad and the information has to be transmitted abroad, and they, to fulfill that order, you have to send that information outside the European Union, right? So in this case, the this is a classical case of contract. To fulfill the contract, if the data has to be transferred outside European Union, then that is also a valid international data transfer instrument. Apart from that, you also have vital interest. Vital interest means in the case of life or death situation, you can actually use vital interest. That generally is a very least used option. So I'm gonna discuss last two topics, okay, which is the transatlantic journey, especially the relationship between the European Union and the US. So European Union and the US have a special agreement for a very long time. The reason is majority of the European Union organization have their backbone in terms of technology, storage, and everything in the US, right? So they have very strategic alignment and partnership for a very long time, and that is the reason they have a special treaty to transfer data outside the Europe to the US. And so if you at all know the Edward Snowden case, that's the first jolt that happened in this particular relationship. All right. So I'm not going to speak about 1995 directive. We will discuss that in a separate chapter, which we have on the history of data protection law. So the first relationship framework that was created between the US and the European Union is called Safe Harbor Agreement. With the Safe Harbor Agreement, you can actually, if you are registered with Department of Commerce, then you can you can receive the information from the European Union. And the first hiccup that happened in this relationship happened because of Mr. Edward Snowden. So he was a contractor working under NSA, which is National Security Agency, and so he made a whistleblowing. What he did is he made the world know that the NSA had undisputed powers. They were able to they were able to heckle into the IT giants which were operating in the US, and they had exclusive access to all this information. So this created important litigation which was started by Mr. Max Krems. So Max Krems created a litigation. It started with Facebook. Facebook Ireland was transferring the data to Facebook US, which was a mother company. And in this case, the Ireland was not able to answer. Ireland Supervisory Authority was not able to answer the question of Mr. Max Krems, and that's the reason it went to the Court of Justice of the European Union, which is the Supreme Court of the European Union. So that court actually gave a very important judgment invalidating the special agreement between the US and the European Union, stating that it violates the fundamental rights and freedom of the European Union data subject. Basically, those unprecedented powers which are given to the national security agencies are beyond any questions. And US was not able to answer that. Is there any control mechanism is there? They had no clue about it, and that's the reason it got invalidated. In 2016, GDPR was brought in, and 2018 it was implemented. So without a special arrangement, there were 3-4 years which was running, and finally they came up in 2016. They came up with the second version, which is the US EU Privacy Shield. So Privacy Shield is the second version, the successor of Safe Harbor. And again, what they did is they did overcome some of the drawbacks which was pointed out in the first judgment, but they created an ombudsman to hear the concerns of the European Union data subjects, and they created controlled requirements, audits. Lot of things were created, but one important point was never handled, was the unprecedented power of the national security agencies. Like they had special provisions to access the data in the US current laws, and that is the reason, again, there was a second version of the lawsuit, which is called Schrems 2 decision, and it again invalidated the privacy shield. So currently, after the 2020, again the US and the EU entered into negotiation of creating an enhanced privacy shield, and finally, they in 2023 they came up with the next version, which is called European Union US Transatlantic Framework, which is the latest version for doing an international data transfer to the US. Hope this history was interesting to you. So, uh, so we did discuss about the international data transfer using your appropriate safeguard, which is doing an SSE or ad hoc contract certification mechanism, binding corporate rules. So, especially if you're doing part of your SEC, which is the most prevalently used international data transfer instrument, in after the Schrems II judgment, the court clearly said that every international data transfer should be individually focused, and they should have a clear documentation of an assessment to ensure that the international data transfer will not affect the fundamental rights and freedom of data subjects. So the terminology of transfer impact assessment was coined, and so these are the 6 important steps which you need to ensure part of your transfer impact assessment. So this is one of the assessments which we do for all the international data transfer, which you do part of your standard contractual clauses, right? So the first step is know where you're going to transfer the data, identify the tools among the appropriate safeguard. Third, assess the third country laws and practice. I will give you an example. There are certain countries which are considered as they give unprecedented powers to the law enforcement agencies. For example, certain small countries, they give powers to the authorities to go and open a cloud server and look at the data which is getting stored, right? So you have to look at such laws in the third party countries and what practices which is being done by the country which by the company which is based out of those countries. So that is a very very important assessment, so that you ensure the same level of protection is being ensured by the company receiving the data, and identify and adopt supplementary measures. If you have found out certain risk in this transfer, you need to adopt certain supplementary measures. It is by having a strong terms in your contracts and ensuring appropriate safeguards, security controls for transit, and how do you actually dispose the data or return the data once the transfer is done. There's a lot of supplementary controls that can be brought in, and then final step is re-evaluate at appropriate intervals of your international data transfer, whichever we are doing, right? So these are the 6 important steps which you need to do part of your transfer impact assessment. All right.